52 pages, that is the number, 52 pages of FBI interview records in the Department of Justice database on a Tuesday, gone by Thursday, not reclassified, not restricted, not transferred to a secure review facility, gone, removed from the public record entirely. And every one of those 52 pages had something in common. Every one of them contained the name Donald Trump. But that was just the beginning. What the missing 3 interviews contained is why the Department of Justice is fighting to keep them sealed. The FBI interview report is called an FD 302. That is the official designation. An FD 302 is the official FBI witness interview record. Every word spoken in that interview goes into the FD 302. Every detail, every document referenced. The FD 302 is legally significant. It becomes part of the evidentiary record. Government suppression of an FD 302 is not administrative. It becomes material evidence in its own right. It becomes the kind of material that prosecutors build obstruction cases around. Now pay close attention to what happens next. This is the document that changed the entire shape of the Epstein investigation. The woman had been interviewed by FBI agents on 4 separate occasions. The first interview was in 2019. That interview covered her account of Epstein's operation in general terms. That interview was released with the public document batch. The second interview was conducted 6 weeks later. That interview asked specific follow-up questions about locations and individuals she had named in the first session. That interview was not released. The third interview was conducted 3 months after the second. A different set of agents. That interview has not been released. The fourth interview was conducted 11 months after the third. A senior FBI official was present. That interview has also not been released. Subscribe to Patel Report Files right now. When those reports are forced public, Patel Report Files will break down what they contain. This is what the cameras did not capture when Raskin entered the committee room that morning. He carried a printed document that was not on the official evidence list. The document was a comparison. 2 columns. The left column showed the DOJ's public statement about Epstein-related FBI interviews released. The right column showed the internal evidence log from the Maxwell trial discovery materials. The numbers did not match. 15 documents were listed in the Maxwell discovery log for this specific witness. 7 of those 15 documents appeared in the public database. 8 did not. 8 witness records, listed, verified, gone. Who decided which 8 would disappear? That is the question the 3 missing FD 302 reports answer. In exactly 47 seconds, Raskin will place that comparison document on the witness table. Watch what Bondi's attorney does with his pen when the 2 columns become visible on camera. Pam Bondi had testified under oath before the committee on February 11th. She had stated that there was no evidence Donald Trump had committed a crime. She stated it directly. She stated it without qualification. She stated it as a matter of official DOJ position. What she did not state was this. Before her testimony, the DOJ had removed FBI interview records from the public database. Those records came from a specific witness. That witness had provided a specific account. That account named Donald Trump at a specific location. That location was Mar-a-Lago. That account was documented in 3 separate FD 302 reports. All 3 had been removed before Bondi sat down to testify. For years, they had said the Epstein files were being released without interference. Today in this room, the evidence of that interference was sitting in 2 printed columns on a table. The Maxwell trial discovery materials are a separate legal record. They are a court record. They were compiled under judicial supervision as part of a federal criminal case that resulted in a conviction. They cannot be retroactively altered. They cannot be reclassified. They are permanent. And that permanent record showed 15 documents for this witness, 15 verified FBI records, 7 in the public database, 8 missing. One of those 8 was an FD 302, session conducted by a senior FBI official. The date of that session was 11 months after the initial interview, 11 months after the first account was given. An interview conducted with a senior official present is not routine. It is conducted when the account has been deemed significant enough to require senior review. That interview was conducted. It is in the court record. It is not in the public database. Drop a comment below right now. 4 FBI interviews conducted with the same Epstein witness, 1 released, 3 removed before Bondi testified under oath that no evidence existed. Do you believe that was a coincidence? Write your answer. I read every single one. The second document was worse. Raskin produced it 43 minutes into his questioning. The document was a DOJ internal review notation. The notation was dated January 14th of this year. The notation directed the department's Classification Review Board to conduct an expedited assessment. The scope was all Epstein-related witness interviews, referencing current or former senior government officials. The notation listed a timeline. Completion was required before the public document release scheduled for January 28th. The public release happened on January 28th. The 3 FD 302 reports were not in it. The expedited assessment had found them and removed them before the release, before Bondi's testimony, before anyone in that hearing room had been told they existed. The log files do not lie. January 14th, expedited classification review. January 28th, public release. February 11th. Bondi testifies under oath. The 3 FD 302 reports are not in the public record at any of those dates. They were not missed. They were removed on a timeline. Now, I need to stop for a second and say this. If the American people deserve to know what those 3 missing interviews contain, hype this video right now. The hype button is right next to like. You can hype 3 times a day for free. We have 7 days to get this into the top 100 most hyped videos on YouTube. Every single hype counts. Do it now, then keep watching. The legal word for what Raskin found in those 2 columns has a specific definition, and that definition does not use the word coincidence. The legal word is perjury. Perjury is a federal crime. It requires proof that a sworn statement was deliberately false on a material matter. The statement Bondi made under oath was that no evidence existed. The FD 302 reports she had removed from the public database before testifying were evidence. They were official FBI records. They were part of a federal criminal case. They were in a court record that cannot be altered. And they contained a specific account from a specific witness about a specific location, Mar-a-Lago. If those 3 reports had been public when Bondi testified, she could not have made that statement. She made the statement because the documents had been removed before she sat down. That removal was documented. The documentation was in Raskin's second column. The next question did not come from a Democrat. It came from a Republican who had co-sponsored the Epstein transparency legislation. Thomas Massie had been watching from the Republican side of the dais for 43 minutes. He is not a lawyer. He is an engineer. He reads documents the way engineers read specifications, looking for what is stated, looking for what is not stated, looking for where the numbers stop matching. He leaned forward and asked Bondi one question. He asked her when she had been informed of the January 14th classification review notation, not whether she had approved it, not whether she had ordered it when she had been informed. The question assumed knowledge. Bondi's response confirmed the assumption. She said that classification review decisions were made through the appropriate internal channels. She did not say she had not been informed. She said the channels were appropriate. Raskin set down his pen. He looked at the 2 columns. He described what those appropriate channels had produced. A timeline, 3 FBI witness interviews naming a current senior official, removed from the public record, before the Attorney General testified under oath that no such evidence existed. He asked whether Bondi found that timeline appropriate. Bondi reached for her binder. Raskin said he had not finished his question. The binder stayed closed. If you are still watching, what comes next is why this video exists. The congressional record now contains Raskin's 2-column document. The Maxwell trial record still shows 15 witness files. The public database still shows 7, and 8 FBI records are still unaccounted for. What the cameras did not capture was this. After Raskin's second round, a senior committee staffer carried a printed request to the Majority Council's table. It was a formal demand for the DOJ Classification Review Board's full January 14th work product, not a summary, the full internal assessment, every page, every decision, every signature. The Majority Council accepted the printed request without comment. The request was added to the committee's formal record. The 14-day response window began that afternoon. The 14-day window has passed. No full work product has been provided. Ted Lieu watched the exchange from his seat at the end of the days. He is a former military prosecutor. He had seen classification review processes used before. He had seen them used correctly. He had seen them used as shields. He noted that the January 14th notation did not use the phrase public interest review. It used the phrase expedited assessment. Those two phrases have different legal implications in the context of congressional disclosure requirements. An expedited assessment conducted on a compressed timeline before a scheduled public release has a specific legal status. That status is different from a standard classification review. Lieu sent a written question to the committee record after Raskin's time expired. Lieu's written question asked for the legal authority, specifically the authority allowing an expedited assessment to authorize pre-release removal of court-verified evidence. No written response has been provided. Those 8 missing FBI records belong to the American people. Hit that thumbs up for Patel Report Files if you believe that statement is true. Bondi left the hearing at 4:17 in the afternoon. She had been in the room for 4.5 hours. She had referenced her binder 43 times. She had discussed Texas crime statistics. She had discussed the Dow Jones. She had not discussed the 3 missing FD 302 reports. She had not discussed the January 14th notation. She had not discussed the expedited assessment timeline. She had not been asked whether the assessment had been conducted with her knowledge. She had been asked only when she had been informed, and her answer had confirmed that she had been informed. Watch her hands, that micro-expression crossing Bondi's face in the 47 seconds between Massey's question and her response, the jaw holding, the hands flat on the table, the particular stillness of someone who has calculated the precise minimum answer required. Not the true answer, the minimum answer. There is a difference between those two things. Raskin's 2 columns documented that difference with 14 verified entries. We have a WhatsApp channel. If you want to know the moment those 8 missing records go public, come find us there. Go to our YouTube profile and tap the WhatsApp button. Takes 5 seconds. The Maxwell trial court record is not going away. 15 documents, verified, permanent. The public database has 7. That gap is 8 records. 8 records in the court log, logged as FBI interviews, conducted over 33 months. Not in the public database that Bondi's DOJ released and called complete. Complete was the word the DOJ used. Complete. Raskin's 2 columns turned that word into a question with 8 specific answers still missing. The expedited assessment notation carried a signature. That signature belongs to a senior DOJ official. That official's name is in the notation. That notation is in the committee record. The notation is not classified. The signature is not redacted. What the signature authorized is documented. What it removed from the public record is documented in the Maxwell trial log, and the gap between what was authorized and what the public received is documented in Raskin's 2 columns. That gap has a name in federal law. That name is in a 4-page letter. Ted Lieu sent it to the Deputy Attorney General 9 days after this hearing. The letter used the word perjury. The response to that letter has not been provided. Share this for Patel Report Files. Share it with someone who still believes those 3 missing reports do not exist. They exist. They are in a court record that cannot be altered. They were removed from the public database before Bondi testified under oath. The timeline is documented. The notation is signed. The gap is measurable. 52 pages, 8 records, 4 interviews, 1 released. That number is not a coincidence. When those 3 reports go public, every word Bondi said under oath becomes a different kind of document, the kind with consequences. Hit the bell.